Good evening and welcome to Lawyers on the Line. I'm Jim Balmer, a founding partner of the Falsani, Balmer, Peterson, Quinn, and Beyer law firm, and this evening's moderator. Tonight's topic is family law. Marriage dissolution, divorce, and custody are the most common legal proceedings in the United States, affecting at least half of all adults. Disputes in a divorce or custody battle can include division of assets, both property and money, and custody and visitation with minor children. Sometimes custody and child support issues arise even when there's been no dissolution, as I think you'll probably learn from talking with our panelists tonight. Speaking of whom, I'm pleased to welcome our three panelists: Andrew Poole of the Poole Law Office here in Duluth, Cheryl Prince of the Hanft Fride Law Firm, also here in Duluth, and Matt Beaumier of the Gerlach, Beaumier Trogdon Law Firm, also in downtown Duluth. Andrew, Cheryl, and Matt are ready to answer your questions about family law. Please call us at 788-2844, or if that's a long-distance telephone call for you, please feel free to call our toll-free line at 1-877-307-8762. So let me start off with the first question for Mr. Poole. In the movies, we frequently hear a lot about whose fault the breakup of a marriage is.
Sure.
Is fault a factor in dissolutions in Minnesota these days?
You know, here in Minnesota, the state doesn't put any importance, or the law doesn't put any importance on fault in a dissolution matter. Perhaps in other states or in the past that was something that warranted consideration, but here it's simply sufficient to conclude there's been an irretrievable breakdown in the marriage, and that's it. You don't have to allege, for example, that your spouse has committed adultery or has done something else that would warrant the dissolution. It's simply sufficient just to conclude that there's been an irretrievable breakdown.
Well, as a matter of fact, the first question we have from a viewer involves a specific situation that could help elaborate on your answer, and this is for Matt. This caller says, "My wife has had several affairs during our 5-year marriage. I caught her red-handed just last week sleeping with one of her co-workers. We have a 3-year-old son. Will the affair help me with my custody case to get custody of the son?"
Probably not. There are situations here, and again, we live in a no-fault divorce world, and that means it doesn't matter whose fault it is. If one party wants a divorce, it's going to happen. But in this case, the judge probably isn't going to hear it. It's probably not going to be relevant. But if one of the spouses can show that a party is trying to facilitate or interfere with visitation of the other, then it can become relevant. But that's a real limited circumstance that hardly ever occurs, so probably not.
Of course, sometimes
Yes.
what happens is that the fact that they're in a relationship means that they're not interested in spending time with the children. So in that case, sometimes the relationship becomes relevant, or the individual with whom they're involved is not somebody you would necessarily want to expose your children to. So again, sometimes that makes that relationship relevant. Not because they've stepped outside the marriage to have another relationship, but because of some factor about the relationship that relates to the children. And it has nothing to do with maintenance, and it's not going to have anything to do with property. It's only going to relate to how the parenting time can be allocated given the best interests of the children and all those things considered.
Well, let me ask this question of you, Cheryl. This relates more to some of the preliminaries in a dissolution. Some might even call it self-help. This caller calls in and says, "My husband moved out of the house 3 months ago. He just served me with divorce papers. Can I change the locks on the house?"
You know, that's a question I get a lot, and the answer in general is yes. Assuming that the house is held in joint tenancy, both parties have equal rights to that property. And so you can both that person can change the locks, but it doesn't mean that that other spouse is prevented from coming into the property. They could break into the property. They could get law enforcement to help them back into the house. You can't keep them out of the house. You can change the locks because it's as much your property as it is his property.
All right, now here's a question for Andrew again, and this relates to the visitation aspects of a custody situation. And the question is this, a caller wants to know, grandparents' visitation rights, why do they not have any? So go ahead and see what you can do with that, and then maybe we'll throw it open to the other two.
Yeah, right, and perhaps I can draw from some assistance from my colleagues here, but certainly, children do develop these relationships with grandparents.
I hope
and
so.
They're, well, right, I did. I love my grandparents, but and more often than not, I think everyone would conclude it would be within that child's best interest to maintain that relationship with the grandparents. Now, there is the ability under Minnesota statute for a grandparent to try to adjudicate their type of interest, or at least have that recognized type of visitation. That's certainly a possibility. But at the same time, if they're not the biological parent, it kind of puts them in a different category of folks.
Correct, and they can, for grandparent visitation, the one thing about it is they can't ask for grandparent visitation unless there has already been a proceeding that brings the children into the courtroom setting, that they're proceeding for a divorce, paternity, or there's an ongoing action. So that's a prerequisite for a grandparent to step in and ask for grandparent time. But once there has been, they can ask for grandparent visitation provided that certain factors are met.
You're going to have to elaborate on that. Let me explain why I say that. Let's suppose that my daughter, I have a daughter and grandchildren, and she decides that I'm not allowed to see her children. Can I go into court and demand a court order that gives me the right to see my grandchildren when she and her husband remain happily married to each other and their kids are with them and so on?
Unless you know something I don't know, but the statute says that
Yes.
in an the statute says that where there has been a existing or previous action for paternity, divorce, legal separation, then the grandparents have rights.
Got
And so
it.
that's interpreted as a prerequisite to allowing you the right to come in and ask for grandparent visitation.
So in the hypothetical situation I just posed to you, the answer is no. I cannot go into court and initiate a proceeding on my own. I can seek rights as part of some existing proceeding or after some other proceeding has been commenced.
Correct. Or you could go in as an interested third party or a de facto custodian and ask for custody.
I
You
see.
can't ask for parenting time. The custody and the de facto custodian and statute is not dependent on a pre-existing thing, but it's custody, not visitation.
Well, a lot of the questions we're getting tonight are about kids, so I'm going to ask Matt this one. Do children ever have the right to choose which parent they want to live with, is the question.
You know, that's one I probably field at least once or twice a week, and it becomes a factor based on the maturity level of the child, the age. Is there a magic number? No. You can have a very mature 9-year-old. You can have an extremely immature 14-year-old. But there are 13 factors that a court looks at, and that is one of them. And basically, the preference of a child as the child grows older and has more maturity level, which we presume is the case, it becomes a much more weighted factor. But the law also says that one factor is not supposed to be weighed over the others. So, you know, all-encompassing, whenever you're dealing with matters involving a child in Minnesota, it's not that they don't care about the parents' rights, but the courts are it's very clear that the best interests of the child are paramount, and that's the number one. But obviously, the court always has to weigh the factors and the rights of the parents. But if we look at something on a pedestal, that would be the rights of that child, the best interests of that child. So.
Okay. Now, this is another one. I'll shoot this to Cheryl, and then we'll come back to Andrew. This question is about apparently a non-marriage situation. And the question is, My boyfriend and I have lived together for 15 years and we have 2 children together. He just left me and told me that I need to move out of the house because it's only in his name. Don't I have the right to half of our property?
Unfortunately, if you are not married and you are living together, you don't have the same rights as if you were married. And even though you've been together for a long time, even though you have created a family, you are not married, and the divorce statutes don't apply. It's unfortunate. I've had situations where people have been together for many years, and they have worked very hard, but the husband, and I don't mean to be sexist, but the male in that case was the primary breadwinner, and the female stayed at home with the children. The statute says that if they're not married, the property is owned by the individual who purchased that property. And so if you can prove that you added value to the property, if you paid the mortgage, if through your efforts you've improved the value, you can go for an equitable share, but it's not necessarily going to be half, and it's going to be a long fight to get a definition of what is yours and what is his.
Well, let's go to the length of the fight and go back to a marriage situation. Andrew, how long does it take to get a divorce these days in Minnesota?
Yeah, well, that's really a common question I hear from folks, and there's no clear answer. It really depends on each case, the issues involved, and the party's willingness to reach a resolution. If they're unable to reach a resolution, then there are ways that folks can get assistance in resolving issues like mediation, early neutral evaluation, forms of alternative dispute resolution, but that takes time. And if ultimately those efforts are unsuccessful, there's always leaving it for the courts and going through that process. So it really depends on the party's ability to come to a resolution. And if they're not able to do that, then it's stretch it out a good amount of time. It could be months.
I knew somebody who actually has spent years in his dissolution action. Now, you used a bunch of terms I'm going to ask Matt to elaborate on because it's his turn. He used terms, I think he used alternative dispute resolution. I heard him say early neutral case evaluation, and I heard him say mediation. Could you please tell us what some of these terms mean?
Sure, and the reason it's we spout these words and these phrases out probably daily, and we forget that people don't hear them daily, but alternative dispute resolution basically means something alternative to the traditional court system. And it can be a good way. I tell people when they come into my office or give me a call that there are basically 2 ways to handle it. You can either control the outcome or you can have a judge control the outcome. And I tell people it's best to try to get that outcome controlled where you have a hand in it, because you never really know what a judge is going to do. And when you talk about mediation, that's a process where a mediator, somebody neutral, will basically go back and forth and try to reach a resolution. Evaluation's a little different because if you have social, that's basically custody evaluation, or financial, which is all the stuff. But basically they'll listen to both sides, look at the law, and they'll tell the people, we think a judge is going to do this if you go to court. And it has a really a great effect on people because they're hearing it, they get to tell their story, they get to hear what a judge may do. And I think last we checked, I think it's 85% of cases resolve. And that's a program that's been in St. Louis County since 2009. And it's been great. You can get your divorce done in a matter of weeks as opposed to months or even the years. And then arbitration's another way. Arbitration is somebody who's going to listen to both sides and then make a decision that you have to live with. I personally don't like arbitration because if you don't like it, the odds of appealing it are very low. It's almost an unappealable award. So you're really stuck with what the arbitrator gives you. So we don't see that much in family law.
Cheryl, speaking of how these things are decided by the courts, one caller called in with this question: child support, and she apparently has 3 young children, and she wants to know, how is child support determined in her situation? What are the factors the courts look at?
Child support is a function of the income of both the mother and the father, the amount of parenting time that the parties have, and the number of children. She can actually go online. If she can Google Minnesota Child Support Calculator, it should take her to the Department of Human Services website, and there is a calculator there. If she can input the husband's income or the father's income and the mother's income, the number of children, and then estimate the amount of parenting time. There's 3 different categories. There's no parenting time at all, and then there's the situation where one parent has the children more, but the other parent sees the children 10% to 45% of the time, and that's the middle category. And then there's the parenting time calculation where they have them about equal, 45% or more. And then she should be able to see the amount of child support and get some general estimate of the calculation in her situation.
Okay, now, this one, well, I've got so many questions that we're getting called in, frankly, that I'm getting a little overwhelmed here. Andrew, here's a question. Does the law allow a person to divorce someone who is disabled? So if we assume that I'm healthy and my spouse is disabled, can I still get a divorce from that disabled person, or doesn't the law allow that?
Yeah, that's an interesting question. That's not a circumstance I've ever encountered, but I'm inclined to say you certainly are going to be able to get to divorce the person. The question is, how is that disabled person, how are their interests going to be represented? Certainly, if they don't have, if they're pro se or don't have an attorney, that certainly would be an issue in my mind, but perhaps you two have some experience with somebody divorcing a disabled person.
Go ahead, Cheryl.
I think you can you divorce a disabled person. I think you're right, Andrew. I think the question is how that disability would affect the property division or the spousal maintenance issues. And certainly if they're disabled, they might qualify for free legal representation through legal aid or through the volunteer attorney program.
And following up on what Cheryl just said, Matt, here's another question that's related to that. What is the responsibility of the ex-spouse to pay medical bills when the other parent brings a child in for medical care? You get me?
Sure.
You understand?
Sure.
Okay,
And
so go ahead.
It's a good question, and it's really, if you look at what happens during a marriage, good or bad, if assets are accumulated or sometimes you got a mountain of debt accumulation, it's going to be a marital asset, or in this case, a marital debt. It's going to be subject to equitable division, so it's going to be a responsibility of both parents.
Suppose that the divorce decree, is that a word still used? Okay. Suppose the divorce decree says that it's 50-50. All medical bills incurred for the benefit of the children will be split evenly. Then so I bring the kid in, and do I have to pay it all and then try to get the money back from the ex-spouse, or what are the mechanics of it?
Yeah, sometimes it can get hairy, where somebody goes in and has a procedure done, and then all of a sudden you're stuck with a bill, and you were the one who happened to sign the authorization to the clinic, and you can turn that bill over, and hopefully the spouse will cough up. If they don't cough up, you can try to get some help from the child support collections, and they'll do that. That's considered child support or medical care. So you can give your ex a nudge and see if that works. If it doesn't work, then you might have to have somebody help you nudge. So.
And child support collections is a division of the Department of Social Services?
Correct. That's
Okay.
correct. And anybody can go in there for collections. They have to apply for benefits, whether or not you're eligible. Once you've made the application, you can have the child support collection move forward with actually establishing support. So.
And then Cheryl, to follow up again on this disabled spouse thing, this caller has this question: married 25 years, has 2 girls, is the mother of the 2 girls or the 2 girls entitled to any portion of the ex-husband's Social Security benefits?
Social Security benefits would be considered his income. And so if when balancing all the factors for spousal maintenance, he has a greater share of the income, that may be something a court would look at. However, I do not believe that you can actually go to the Social Security Administration and divide it at the source. It would have to be done in a different fashion.
Okay. Now, Andrew, this person has a question about a quadro. What is a quadro?
A quadro is called the Qualified Domestic Relations Order. Consider it, I guess I'd call it a tool, is easy way to understand it. A tool used to separate, to divide private retirement plans, 401ks. It's an order of the court that would be required to separate that, so each party to the dissolution can receive the agreed upon amount or required amount that is required by the judgment and decree. It only applies to private plans. So para, for example, something that's a creature of state statute, wouldn't require a quadro. Perhaps a domestic relations order, or you could otherwise put it right in the stipulated agreement itself. But that's what a quadro is. That's what it does.
This caller asked this question. What recourse does he have if there is a stipulated quadro and the ex-spouse is not providing the account numbers for the purposes of division of the retirement funds covered by the quadro? Do you have any advice for them?
Yeah, certainly in a judgment and decree, parties are required to execute any documents oftentimes that are necessary to affect any agreement. So if he's withholding that information so as to not do that and essentially obstructing the process, perhaps there could be some recourse in court through a contempt action or something like that.
And I also think that you can write directly to the plan administrator, and there's a state statute that requires that they provide certain information regarding the plan.
Now, this is a question for you. I'm not quite sure why it's being asked. Why did Cheryl change her answer from the husband to the male? I think I know, but I want to read the question, so.
What was the original question?
I don't know. It could have been about custody or visitation.
It was about custody or visitation. If I changed it from the husband to the male, it was probably because you can have custody and visitation in situations where the parties aren't married.
Right.
If you have children.
That's what I would have thought, but I wanted to ask the question so that. Now, who here practices dissolution law in Wisconsin?
I do.
I do too.
You do too. Okay. Well, then I'm going to ask her this question because the last one was kind of a short one. Here's the question. My husband inherited our house, I assume from his parents. My name was never on the title. After 20 years of marriage, we are now divorcing. Do I have a right to half the house? This is in Wisconsin now.
In Wisconsin, in both Minnesota and Wisconsin, property that a spouse inherits or receives as a gift is considered non-marital property.
And so?
So initially, it starts out as non-marital property. However, you can add marital value to a non-marital asset. You can improve or increase the value by improving the property, adding a room, putting on, renovating the kitchen. So if you take your money or your time and you add value during the marriage, that portion of the value of the property may be marital. In addition, if there's a mortgage on the property or if there has been a mortgage on the property and you use money that is earned during the marriage and you decrease the principal balance of the mortgage, you are also creating marital equity in what is initially a non-marital asset.
And non-marital assets belong to the person that brought them to the marriage, and marital assets are to be divided between the parties to the marriage. Do
Correct.
I have that
Good.
right?
Yeah, very good clarification.
Okay, and Matt, you keep nodding your head when she talks, so I assume you agree with her?
I was just nodding off.
Oh, okay, all right, okay.
No, I do agree with her 100%.
Right. Now, here's the next question from a caller, and I assume this is Minnesota, but if it's different in Wisconsin, Matt, I'll ask you this one. Mm-hmm. If a person is ordered to keep a spouse, or I assume ex-spouse, covered under medical insurance, does this become null and void if that party then remarries?
Usually, I
assume the person who's supposed to be covered marries someone else.
It's very rare to see somebody ordered to continue to keep insurance, and most insurance plans won't cover a former spouse. But I guess the question is, if you've got a court order that requires you to keep your former spouse under your medical insurance, I don't think that the creation of the next marriage is going to obviate that. If there's a spousal maintenance award, The remarriage of the recipient of spousal maintenance, that will terminate maintenance, but this is kind of a specific question, and I don't necessarily think that would get the person off the hook to insure. So.
Okay, now I'm running low on time, so I'm just going to ask this question. First of all, Andrew, I might have time for 2 questions, but keep your answer to 10 seconds.
Okay.
Can we save money by having one lawyer draft the divorce papers instead of each of us having a lawyer?
Well, the short answer is yes. Ultimately, I only agree to represent one party. I'm not sure any attorney would agree to joint representation in a divorce.
Why not?
Well, because it kind of puts them in a difficult position or a conflict of interest, because it's hard to advise both of them. But if there's an agreement up front and one party's comfortable with waiving their right to an attorney and it's a matter of drafting it, yeah, you can save a lot of money doing it that way.
Yeah, and I think it's important to note, I think ethically an attorney cannot represent both parties. And some people believe that if they go to one lawyer, that lawyer is representing both of them, but that can't be the case.
Okay, well, thank you very much. Thanks to all 3 of you. This has been a very informative program. That's all the time we have for tonight. Remember, you can watch our show again online at www.wdse.org or www.duluthtriallawyers.com, and I wouldn't be surprised to see that you could enjoy access to this program on the websites of these 3 lawyers that were good enough to come to us this evening. If you have additional legal questions, you can access the Volunteer Attorney Program's Ask an Attorney service by calling 723-4005, area code 218. Please join us again next week when we'll be talking about estate planning. I'd like to thank our panelists for their expertise this evening and thank you for watching. I'm Jim Balmer. Good night.